Good morning, good afternoon, and thank you for joining the State Attorney General's Antitrust and White-Collar Investigations, What You Should Know, presented by BakerHostetler. This is the final webinar in a three-part CLE webinar series that we've offered, providing vital insights into antitrust and white-collar issues and investigations. The first two webinars concern the FTC and the Department of Justice. This one concerns State Attorney Generals. This will be an off-the-record conversation. My name is Carl Hittinger. I'm the practice team leader for BakerHostetler's Antitrust and Competition team. I will be moderating the webinar today. Alex Schrager, our marketing manager, will now provide you with some pertinent information that you will need to obtain CLE credit. Alex?
Hi, good morning. Our program today will last an hour and is approved for 1 hour of CLE credit in California, Colorado, Georgia, New York, Texas, and Pennsylvania. New Jersey credit is available via reciprocity. Credit is pending in Florida, Ohio, Virginia, and Illinois. For all other states, attorneys can receive a certificate of attendance and electronic materials so they can file directly with CLE credentialing entities. During the course of the webinar, we'll share two codes that you'll need to enter into a brief CLE questionnaire immediately following the program's conclusion. Once the webinar has ended, please look for a small pop-up on your screen. Click Close for your CLE quiz to appear in your browser. Please make sure to answer all of the questions if you'd like for us to submit for CLE on your behalf. If you have any questions during the presentation, you could type your questions in the bar on the right side of your screen in the questions area. We will try our best to answer them at the end of the program, time permitting. If not, we will follow up with you after the webinar to answer those questions. We will provide our contact information at the end of the program so that you can contact us at any time with comments, suggestions, concerns, or questions. We also will send an email to everyone in the next day or two with a link to a recording of the webinar.
This is Carl Hittinger again. I'd like to introduce our presenters for today. You'll hear in this order. The first presenter is Jeff Martino. Jeff is the former chief of the Department of Justice Antitrust Division office in New York City. He's now a partner in our New York office as part of our antitrust group. Our second presenter will be Sean Cleveland. Sean is a new partner in our Houston office. He is a member of our white collar group as well and has a great deal of experience handling defense work in various matters against the state and federal government and working with and against state attorney generals around the country. And our third presenter will be Steve Dettelbach. Steve is in our Cleveland office. He's the co-head of BakerHostetler's White Collar Investigations and Securities Enforcement team. He's the former U.S. attorney for the Northern District of Ohio. He's also a former Democratic nominee for the Ohio Attorney General's office. And again, he's in our Cleveland office. So let me start by talking about the subject areas that we're going to cover on the first slide. Slide 4. We're going to first start talking about the intersection, the interaction between state attorney generals and the Department of Justice, and those what we call partners in prosecution that have to often be dealt with. The second area we're going to talk about is state attorney generals and their enforcement priorities as we see it presently and going forward. We're also going to talk about understanding and navigating the tremendous rise of multi-state attorney general investigation and how to best coordinate that activity going forward. And finally, we're going to talk about state attorney generals and other responsibilities and priorities that they have both in criminal and in the civil sphere. With that, I just want to make a mention of something which will kind of set up these presentations as we go forward. The first issue is, as you know, in the civil context, there is, coordination between the federal, the FTC, Department of Justice, and state attorney generals on merger and deal review. That can often lead to litigation, both civil and criminal, depending on how those matters play out. So there's a coordination that has to take place there. The other thing I want to mention that will set this up a little more is that, as you know, or as you should know, there have been, turf wars, I would call it that because they are, between the Department of Justice and the FTC concerning who can investigate certain industries. And this is now going on with big tech, where there's a disagreement between the two agencies as to who can investigate. And of course, if you then throw in the state attorney generals, it makes it even more complicated. So having set that stage, let me turn it over to Jeff Martino. Jeff?
Thanks, Carl. I appreciate the introduction, and I want to begin my remarks by stating that, obviously I'm not with the Department of Justice any longer. I'll be talking about, some of my observations. These were my personal observations about investigations where at the time, I was with the department and in coordinating with states, or at times not coordinating with states, depending on the situation. So we'll go into that. It's a pretty high-level discussion. As Carl said, I encourage that if there are questions from the audience to submit those, and so we can continue to have a lively discussion after we finish through each of our presentations. So what I'm going to kind of highlight, what I'll talk about today for a few minutes is basically the conditions that give rise to a parallel or joint investigation by the Department of Justice and State Attorney General's offices. Then I'll define technically what those terms are and what they mean and how they play out in practice. And then we'll give some high-level best practices that companies should consider as they're navigating. What I'll say is, and you see on this first slide, is really could be a storm. So obviously, the states and the federal government can conduct these joint civil or criminal parallel investigations, joint or parallel investigations. How this comes about, these are the conditions, really depends upon where each is in its investigation, whether one has started looking into the industry already. Another condition is whether what the past relationship is between the agencies at the federal level and the state level. For example, in New York, where I was chief of the antitrust division there at the New York office doing criminal cases, it was quite common for me to interact with my counterparts at the FTC, other federal agencies, but also with the Antitrust Bureau at the State Attorney General's office on just generally policy, but also as well as where cases stand, if we could talk about them, and we'll get into a little bit of that. There are some limitations on what you can disclose at the federal level and the state level when you're conducting a criminal investigation. Other conditions that may exist that will tend to factor into whether the two or three agencies at the state and federal level are going to coordinate is just what are their interests. State agencies are, I'm not going to say completely political, but most state AGs are it's an elected position, so they are really worried about what the public perception is of their constituents in their state, and that may drive them to conduct investigations in a certain way, depending on as far as timing, and really wanting to get out ahead and make sure that from their perspective they're addressing those constituent concerns. So joint investigations. Basically what this would be a complete integration of the teams. Whether you're federal and state, basically they'll all be sitting at the same table, talking, discussing, sharing the information with each other. They're going to have a coordinated investigative strategy. That means for companies that they'll be responsive to probably one request from that team. Now, this is probably the exception rather than the rule, is what we'll talk about, and you'll hear from Sean and Steve more about this. But there are situations both in the criminal sphere as well as in the civil sphere that they can operate as one team. And what that certainly will do is, we talk about one resolution. If that's the case, where you've got this one team, you're going to have one resolution that's going to address the interests of the state concerns and the federal concerns all at once. I mean, this is probably the most efficient way to get it done from our perspective. If there is both entities at play here. There is a recent Department of Justice policy that has been issued where the department is really against piling on. That means having duplicative duplicate penalties or damages where you're paying like 2 or 3 times for the same conduct. The Department of Justice is going to consider what penalties or restitution is being made to other agencies, and will try and limit what it collects. That's what the recent policy is. That is a change, but it still is an open question on how that's going to play out. And we'll talk a little bit more of that today. But certainly, where there's a joint investigation, the risk of piling on is going to be less. And some examples, or one example of a joint investigation between the federal and the state agencies is there was a tour bus, 2 tour bus companies in New York that formed a joint venture, and the allegation was that they monopolized the market. Both the Department of Justice, the Antitrust Division in New York, State AG sued the 2 largest hop-on, hop-off tour buses for conducting that conduct. And there you had essentially them all sitting at the same table, and there was one overall global resolution. So parallel investigations. This is where the agencies are operating on separate paths. You're going to be facing a multi-front war. There's going to be less information sharing. Information sharing that will occur will be more about timing of major investigative steps. Maybe they'll discuss that. They may discuss any public announcements. The hope is, between the 2 agencies that they're going to do that. But at times, because of perhaps different interests, that may not happen. And in those cases, it's likely that there's going to be multiple resolutions. And this is where that piling on policy is really going to, have to come into play. And a real effort is going to be needed to be made to try and corral these various investigations to try and resolve in a manner that's as swift as possible and as comprehensive as possible, so you can limit what's going to happen in the future. Example of this type of parallel investigation is the LIBOR case, where you have the Department of Justice, both the Criminal Division and the Antitrust Division, conducting investigation and prosecution in the manipulation of the London interbank offered rate. This is a benchmark for home loans and student loans. Here, there was obviously, this affects, the economy at large, and so there's obviously a large federal interest, but the states also are certainly involved and have a considerable interest. And there you had criminal prosecution by the Department of Justice, and then a follow-on, what we refer to as a follow-on federal civil claim by the states. And in this particular matter, New York has been leading a coalition of about 40 state attorneys that filed a complaint in federal court, and also resulted in hundreds of millions of dollars in bank settlements. What's interesting to note here is when you do have a federal criminal investigation and then a parallel state investigation that's civil in nature, but under basically the same, having the same claim, is that the federal government will seek to stay the proceedings of the civil investigation and the civil claim until the criminal case is over. The Department of Justice will seek to do that. It's up to the judge overseeing that civil case whether he or she will stay their proceedings. It's becoming more unlikely for courts to do that, just give a blanket stay. They may do so from from 3 to 6 months, and then ask the Department of Justice to come back in and give an update ex parte to the court. There may be continual stays, but judges are more and more inclined to try and move their civil matters before them along. But that is a consideration as to whether you're going to have to be facing claims that are already filed in federal court that are civil in nature, while also responding to Department of Justice criminal investigation and requests from the government at the same time. Even despite companies that are countering the civil claims also going into the court asking for that stay, courts are becoming more and more inclined to limit those stays to a limited time period, as I mentioned, or not do so, not put a stay in at all. So just as it's a huge headache and a storm from the outside, inside there's some real competing considerations on whether the Department of States are going to be joint or go parallel. I briefly mentioned that there are secrecy rules. The Federal Rules of Criminal Procedure under Rule 6E limits that any matters occurring before the grand jury, before the federal government criminal investigation, if it's a grand jury investigation, that information that is before that grand jury cannot be shared outside the team of prosecutors at the federal level. And so that's going to limit the ability of the federal government and states to cooperate and coordinate, perhaps, and share information. Really, it goes to the evidence that they'll be able to share. Another very problematic issue is that if you have an ongoing criminal investigation, or if the government has this ongoing criminal investigation, they're going to be concerned about their own discovery obligations if they do file a criminal case, and whether those discovery obligations that they have as the criminal prosecutors, it's their obligation to provide the material that they believe supports their criminal prosecution, as well as all relevant material. Now, if they're in a joint investigation or conducted a close investigation, a coordinated investigation with a state AG, that state AG may also have to provide discovery in that federal criminal case. And so these are some of the concerns that the Department of Justice is considering at the time. And then, ultimately, if there's a criminal investigation and a parallel state investigation, they've got to consider when and how often they're going to communicate with each other. And I mentioned this a little bit earlier, just about they've got to figure out at the outset how often and what particular times they're going to discuss the issues, discuss the evidence, if they're allowed to, discuss timing of any future filings or any future claims or any future prosecutions. And this is an issue for them because they're not always, their interests aren't always aligned, and the status of their investigations may be at different points. So here are some high-level best practices that we encourage, and what we try and do when we've got these multiple agencies interested in industries that we have clients in. First is be proactive, obviously, and try and address both interests up front. Try and figure out what, if there is combined interest, and so you can address that. And it's important to communicate. Communicate as much as you can with both agencies, and encourage them to communicate so that it alleviates the difficulties in providing them the information. You're going to want to focus, again, on getting a global resolution, dealing with or addressing all the concerns of the federal and state agencies, as well as any other parallel investigations out there. And so that way, to the best you can limit the litigation going forward. It's important to consider the collateral consequences, and when the collateral consequences in this context, and some of them, this is not all of them. I mean, each company will know what its collateral consequences will be, but certainly there's going to be reputational issues of taking, some type of plea or entering a resolution with any agency. There may be debarment issues where it'll preclude the company from providing services to the government or to its customers in the future. And then, what other business impacts are there? Are there going to be shareholder suits? What does the company need to consider? And that's an analysis that we go through and have significant experience in helping the company identify what its particular collateral consequences are. And the last one is obviously, you don't want to shut one agency out over the other, because that ultimately defeats the purpose of what we're trying to get done here, is resolve, get this hopefully declination, everything wrapped up. If there needs to be a settlement or some type of resolution where there's an admission of guilt, or at least that the facts are put out there, we'll want to make sure that both sides are satisfied with, both sides meaning both the government and the state agencies are completely satisfied, and there's not going to be any lingering discussions after the resolution or the first resolution is entered. And so with that, Carl, I'll pass it off to you, and we'll dive into more of the subjects.
Very good. Thank you very much, Jeff. I'd like to turn it over to my partner, Sean Cleveland. Sean?
Okay, thank you. So we'll talk a fair amount in this presentation about antitrust enforcement by state AGs. In this part of the presentation, however, I'm going to talk about other types of enforcement priorities that the state AGs have, and particularly with regard to big tech companies and with regard to data privacy and security. But we'll first go through kind of an overview of the various areas that they are focused on at the AG level, and then we'll talk in a little more detail about the data privacy and security issues. At a high level, state attorneys general will have a lot of significant enforcement priorities that change over time, and certainly beyond antitrust. In the current environment, many of these priorities will be used to supplement or in conjunction with major antitrust investigations, again, particularly of big tech companies. State AGs will continue to be very active in privacy and data protection issues, and what you'll see them doing is using general consumer protection statutes to go after insufficient data protection, for consumers, for users, by tech companies. And that's in the absence of a standardized federal regime on privacy and data security to some extent. We have more of a patchwork of things that apply rather than a uniform statute, for example, like they have in Europe. State AGs will use those consumer protection statutes to go after an attempt to conceal or a failure to disclose a data breach as well. So I'll now talk through sort of at a high level some of the different priorities aside from privacy and data security. One area is opioid marketing. We all know opioid addiction has devastated a lot of communities, particularly in rural areas through the United States. And the state attorneys general have launched actions against opioid makers and distributors, claiming that they improperly marketed the opioids and downplayed their addictive qualities, among other things. Nearly every state has filed suit against some of these opioid makers. This is leading to uncertainty around some of those companies in terms of their future. Four attorneys general recently unveiled a proposed $48 billion deal with major drug companies and distributors to resolve a wave of opioid crisis lawsuits. Again, $48 billion in that resolution. The next area I'd like to mention is e-cigarette marketing practices. We've seen that e-cigarettes are causing a spate of illnesses among some users, particularly young users, raising concerns about their overall safety, and the state AGs are investigating that, investigating in particular whether those are being improperly marketed to minors. North Carolina and Massachusetts have brought consumer protection actions against e-cigarette companies for allegedly targeting youth, and the New Jersey AG is seeking information from 15 e-cigarette businesses about their marketing and sales of vaping products in New Jersey. Healthcare fraud is a significant priority for AGs, has been for a long time, and will continue to be, particularly as to Medicaid fraud. With continued increasing medical spending, it's an important area for enforcement and for controlling expenditures. Some examples, recent examples: following a 2-week trial, a physician in the District of Columbia was found guilty of 1 count of healthcare fraud and 16 counts of false statements in a healthcare matter for billing Medicaid over $700,000 for procedures and office visits that never occurred. Alaska's largest Medicaid fraud case involved the owner of a home healthcare agency pleading guilty to a felony count of defrauding the Alaska Medicaid program for over $1.3 million. To anyone who works in this space and deals with healthcare fraud, these are familiar, and there are lots of other similar patterns that you see repeated, but that's going to continue to be an area of enforcement. Housing is another area. State attorneys general appear to be following the lead of the Department of Justice in investigating discrimination in housing loans. The Pennsylvania Attorney General recently announced a plan to focus on redlining and solicited input from consumers with potential redlining tactics or irregularities that are out there. Similarly, the New York Attorney General has been active in bringing enforcement actions for discriminatory lending practices and continues to ask for complaints from New Yorkers as well. Civil rights is another area. We have highly publicized recent instances of police violence and the cases and investigations involving those. The Illinois Attorney General recently entered into a consent decree with the Chicago Police Department regarding its use of force and preventing potential civil rights violations. The New Jersey legislature recently passed a bill allowing the Attorney General to investigate all deadly encounters with the police, including deaths occurring when in police custody. So I'll now turn to a little more in-depth discussion on some of the developments in data privacy and use of consumer data as AGs are scrutinizing that. As some of our other speakers are discussing, both federal and state authorities are engaged in significant antitrust investigations of big tech companies. But it has to be acknowledged that these activities don't neatly fit under federal antitrust law or other federal law in many cases, in part because these companies do not charge consumers for their products. So state attorneys general are investigating issues of data privacy, both with big tech companies and other companies that misuse or fail to protect their users' data. And they do this primarily under the auspices of state consumer protection statutes. A couple of cases are worth highlighting here. The District of Columbia AG was the first to file a formal action against a social media company for alleged failure to protect consumers' data. The Attorney General alleged that the company's failure to protect data violated the district's Consumer Protection Procedures Act, or the CPPA, which prohibits any person from engaging in an unfair or deceptive trade practice, including misrepresenting as to a material fact, which has a tendency to mislead, failure to state a material fact if such failure tends to mislead, or using innuendo or ambiguity as to a material fact, having a tendency to mislead. In this case, the company moved to dismiss the complaint on the grounds that the alleged acts were not covered by the CPPA. The complaint had alleged that the company allowed a developer to use a third-party app to collect users' personal data and browsing data, which was then sold to another third party, and alleged that violated the CPPA by in part failure to monitor and enforce consumer protection policies, failure to ensure that the data was deleted from the third party's database once the release was discovered, and failure to alert the public of the sale of users' data. The company had argued that these allegations, even if true, didn't violate the cited provisions of the CPPA because it didn't involve deception. And the court disagreed, focusing on various statements by the company as to how it would protect or limit the use of consumer information. It's worth noting that in this context, there's a real difficulty for companies and I think a real corresponding difficulty for prosecutors regarding deception, because there's just a fundamental practical problem in policing how millions of users or millions of third parties, in some cases with really large data businesses, are using the data. It's not only impractical, but there's just a fundamental problem with placing that burden sometimes, and particularly when there's not evidence that would support deception. But nonetheless, these sorts of statutes are being used. Another example is the state of Indiana bringing a case against a medical information company. State attorneys general are 16 of them filed a complaint against an Indiana-based company, its subsidiary, that suffered a data breach. The company licenses a third-party web-based application to healthcare providers, and through a subsidiary maintained and provided patient records services to healthcare providers that allowed the patient to access its own records via a portal. A hacker got access to the company's system. It was through a relatively simple process. They found 2 publicly accessible accounts that had previously been used to test the system. The usernames matched the password. They gained access, and it's not a novel method, but gained access to 2 of the administrators' accounts, and then were free to collect patient data, which was unencrypted. So several failures there that are pretty basic and that were exploited. Although the company violated several HIPAA regulations, allegedly, the 16 state attorneys general brought a consolidated action under their respective states' consumer protection statutes, as well as state privacy protection acts for the states that had enacted them. There was no indication of any intentional deception, anything of that nature. Nonetheless, these unfair and deceptive trade practices statutes are being used. The company in that case entered into a consent judgment in the case rather than fighting the claims under the various state consumer protection statutes. And the result being that the state attorneys general were able to make up for the lack of a specific federal privacy protection statute by combining to bring actions under their different consumer protection statutes. Finally, I'll talk about a data breach incident involving a ride-hailing company. As you may have seen, this significant settlement involved payment of $148 million to resolve claims by 50 states arising from a 2016 data breach. In that case, in November 2016, the company learned that hackers had obtained personal information such as phone numbers and email addresses of over 50 million users worldwide. They'd also obtained driver's license information for many of the drivers. They had been able to access the information by stealing credentials to access cloud storage. The hackers then contacted and informed the company of the breach and demanded $100,000 in extortion to delete the stolen data. The company allegedly complied without contacting law enforcement or regulatory authorities. And then when the new CEO became aware of this, there was an authorization of an internal investigation and contact with regulators. Like the previous cases I've mentioned, this company faced suits by state attorneys general under those states' consumer protection statutes. Those states with data privacy statutes, like California, alleged violations of those statutes. But the California AG also alleged that the violation of privacy statutes violated the state's Unfair Competition Act as well. Other states like Texas brought claims under their Deceptive Practices Acts. Those states alleged that the company violated the Consumer Protection Acts by both maintaining inadequate data protection systems and by failing to immediately disclose the breach. So that gives you a good sense, again, to recap, state attorneys general have a lot of enforcement priorities, but many of them are directed at large tech companies with millions and millions of users, and they're pursuing actions against these companies, primarily using those varying state general consumer protection statutes. So that's something we all have to be aware of and ready for going forward.
Sean, thanks very much. Appreciate that. Very helpful. And I'd like to now turn it over to my partner in Cleveland, Steve Dettelbach. Steve?
Thanks, Carl. So following Jeff and Sean, there's a tough act, right? So I reminded the old saying that everything has been said, but everybody hasn't yet said it. So I will try to streamline my comments as best I can to just sort of try to fill in or maybe add to the, I think, really insightful comments that we've been listening to, and then make sure we have time for a discussion and some questions as well. I guess, the first question is to sort of talk a little bit about the overview of what happens when state attorneys general start looking at matters. So the first bullet point says expanding jurisdiction. So we've talked a little bit about that, but what do I mean? I mean that if you look over the arc of the last 50 or 60 years, there's just no doubt that state attorneys general have and continue to assert themselves in ways that I think attorneys general in the mid part of the 20th century wouldn't have imagined. Many attorneys general's offices during the 1940s and 50s were sort of just, glorified Better Business bureaus that had limited staff and not a lot of ambition in terms of making policy difference or larger impact on our economy or the communities. And that, of course, year by year has changed and is now anything but the case. State attorneys general, I think, in most states, start from the notion that these kinds of larger enforcement issues are theirs unless there's a good reason why they're not theirs. And we can talk about what some of those reasons might be. But if you look around, you'll see that in the area of consumer protection, in the area we talked about of data privacy, civil rights, even national security, state attorneys generals continue to assert themselves in new areas. And sort of the next bullet point talks about partisanship. And so there's sort of a tale of two attorney generals on that one. And on one hand, I think we all know that the majority of work in state attorney general's offices is done by nonpartisan career lawyers who are largely subject matter experts and not so political. And they're like the lawyers at the Department of Justice or the other federal agencies, just in there every day, kind of trying to do what they think they need to do to enforce the statutory scheme they've been entrusted with. However, the agencies, and I think Jeff pointed this out, are run mostly by elected officials. And that, of course, can be a defining difference between these state regimes and the federal regime. So new attorneys general get elected. New attorneys general have different philosophies. New attorney generals have different priorities. And there are 50 of them, right? So not only are there new priorities that sort of happen in waves among all the states, but each attorney general might decide that they have new priorities. Is that partisan? I don't know. It's fair to say that that's partisan. It's ideologically driven. But of course, there are also partisanship that does come into it. I would say this. I still think in an era of hyper-partisan activity more than ever, state attorney generals still serve as one of the very few exceptions to the rule that we seem to be facing, which is there can't be bipartisan coordination. If you look at some of the things, some of the cases that we talked about, some of the multi-state cases, some of the cases involving 10, 12 states, you'll see that in a lot of them, not all of them, but in a lot of them, the attorneys general go to great lengths to try and make sure that there's a bipartisan coalition that works on these issues. So in some ways, we're facing an era of increased partisanship and ideologically driven activity on the part of state attorneys generals. In some ways, the attorneys general are still holding the line that there can be some sort of a bipartisan coalition or effort to try to do enforcement. So let me just talk about some of the targeted areas that I think that are sort of, and I'll put it in quotes, new areas of interest. And they're not new, of course. So we've already heard Sean talk, I think, really well about tech companies. So I'm not going to say anything more about that. Of course, you know, it's very public, Google's investigation. Again, I just bring this out to talk about the sort of pushback on the notion that everything's partisan, right? Google, the investigation is being led by Ken Paxton in Texas, a Republican, and Facebook is Letitia James in New York. And both have bipartisan coalitions. Data privacy, I think we've talked about, but I want to say a word or two because I've worked on some of these cases also involving data privacy. So I think, you know, this is a real area that I think, you know, to me ought to be scrutinized going forward. It's become routine that whenever a company experiences a breach, almost every single time, there's sort of a rush of a whole group of attorneys general to try and armchair quarterback the data privacy and security of the company and exact a fairly large settlement, usually accompanied by a pretty oppressive consent decree. And of course, those kinds of remedies are appropriate in some cases. If there really is a failure to kind of do very basic hygiene and security to protect personal information, of course. But, you know, when a company finds itself hacked hypothetically by a unit of the Army of the People's Republic of China, one of the most sophisticated hacking organizations in the world, and then they find themselves getting called by the attorneys general not to help investigate and limit the damage caused by this foreign government, but to punish again the company that's been hacked. I think we need to search for balance. I think that's something going forward that we really ought to think about is how can we make sure that we understand that not all of these cases are created equal, not all are the same, and that we ought to be open to resolutions or just taking a pass on cases where there really isn't an important public interest to vindicate by changing conduct. It's just sort of this sort of search for a flashy case. And I say that with respect because I do believe that the consumer protection people in Attorney General's office are kind of trying to do the right thing in most circumstances. But I do think we've gotten caught a little bit in the spin cycle on this one. It's something we ought to think about. And then the other one I want to add, because I don't think we've talked about it, is the idea of wage theft as a priority. And state attorneys general in Illinois, Minnesota, Massachusetts, and Washington State, among some others, I think District of Columbia as well, have launched individualized effort aimed at wage theft. Now, what is wage theft? Wage theft is sort of the generic term for a variety of conduct where employers are, for one reason or another, not paying either all the benefits or all the compensation that people who should be W-2 employees are entitled to. So these range from, you know, small construction business paying people under the table so that they don't have to pay any workers' comp or FICA tax, to large companies who are misusing independent contractor designations that attract the attention of state attorneys general. All of these different things sort of fall into this idea of wage theft, and it is also one of the new areas that state attorneys general are focusing on. The last area that state attorneys general are focusing on, which is not listed here, but I want to talk about, is in the last two administrations, the Obama administration and now the Trump administration, state attorneys general have taken a very active role in actually challenging actions by the federal government. The best two examples that you can think of from the news are in the Obama administration, and still to this day, a group of Republican state attorneys general challenged and continue to challenge the Affordable Care Act, Obamacare. And on the other side, it was a group of largely Democratic state attorneys general that mounted a challenge to President Trump's travel ban. And so these are areas where you are much more likely to see partisanship, because the kinds of issues that are raised in these cases are far more ideologically driven. They're far more predictable in terms of who's going to line up where on these cases. And this is an area that, again, I think if you're talking about sort of new frontiers in state attorney general conduct, this is really, in the past 10 years, the newest thing. I don't think it would have occurred, again, even in the 70s and 80s, to many, many state attorneys general to sort of operate as a check, a state check on the exercise of federal executive power or federal, even congressional power. And it does certainly now occupy a huge, huge percentage of the cases that are brought by state AGs in those areas. So the last thing that I want to talk about is just I want to say a word about multi-state attorney general litigation. And so this is an area that has grown and has continued to grow. I mean, the first multi-state action goes way back to over 100 years ago with the founding of NAG in the early 1900s. And it was developing a strategy that ended up taking on Standard Oil Company. But things grew very slowly for a long time, and sort of it wasn't very common to see a large group of attorneys general that were involved in those kinds of cases. That's changed, of course. I mean, now state attorneys generals have lost hundreds and hundreds of cases against the pharmaceutical companies, the tobacco companies, all the different areas, the opioid companies, all the different areas that you've heard talked about by the people who talked before me. Over 40% of all the multi-state cases that have been conducted since 2000 involve over half of the nation's attorneys general. So think about that. That means a huge percentage. You're dealing with not 10 or 15 even, but 25, 40, 45 state attorneys general at one time. Now, there's some things that are opportunities, and I think Jeff talked about those, getting a lot of matters resolved quickly, but there are also pitfalls in dealing with that number of people. First of all, every attorney's general office does it a little different. And, those people who practice in the area smile because everyone does it different, but very few acknowledge that anybody does it any different than they do. So you have these situations, for instance, where some attorneys general's office handle all these matters in-house with their career consumer staff, but other attorneys general bring in outside plaintiff counsel, make them special counsel to the AG, and they're the ones handling the matter in the name of the AG. There are differences in how people handle investigative demands. And this is a really important thing for me to flag early in the case. The last thing you want to have to do for one of your clients is to go through the process of responding to an investigative demand for an attorney general or for a federal regulator or enforcer, and then 6 months later, respond to an almost identical demand, almost identical, but not actually identical, and incur the huge extra expense on behalf of your client to do the same thing, but not quite the same thing a second time. So you want to be thinking ahead, as Jeff said, as to whether in an early part of the case, you can get more people involved to agree on what the investigation and discovery is going to look like. And then at the end of the case, if you are talking about a resolution, there are real challenges to settling one of these cases, a multi-state case. So, of course, the way it works is there's an executive committee. The executive committee are the one or two or three states that really have the lead in the matter. And that's who you'll end up doing your negotiation with, of course. The problem, as I and I'm sure others have found out, is that in the end, the multi-state recommends settlement, but you might have, and others may have been in this position as well, where 1520 state attorneys general don't like provision 2B4 of the provision of the settlement, and they want to renegotiate that part with you. And you may be in a situation where you have to deal with that. And my advice on that is, you should really try to have an open and honest conversation with the executive committee ahead of time as to whether that's going to happen, and also what the executive committee is going to do for you if you enter into the settlement and that starts happening. Because really, it is the colleague attorneys general's office who took the lead in the investigation who can, if they want to, be really strong advocates to advocate for the merits of the settlement that you reach with the executive committee. And you should have that discussion. Don't be afraid to have it, because if you don't have it and people start trying to fly spec and nitpick the agreement, you're going to find yourself in a tough place. So I'll end by saying there's another frontier out there. If it weren't hard enough for companies and our clients to deal with the federal Department of Justice, the alphabet soup of federal regulators and enforcers, and the 50 plus state and territorial attorneys general that govern their lives, we now see the specter of local and county governments that are also bringing actions to try and affect these kinds of changes. Of course, the opioid litigation is just one of those. And so that's for another call, another time, but all of our clients and all of our communities are facing those challenges moving forward as well. Thanks.
Steve, thanks very much. It was very insightful and very helpful. As we said at the beginning, you can ask questions by just typing it in the little box on the right. While you're doing that, let me start posing some questions to our panelists and get into some of the issues. So we talked about turf wars between the FTC and the DOJ. The presenters have gotten into struggles and turf wars between the Department of Justice and state attorney generals, among state attorney generals. Steve's talked about partisanship. Sean's talked about priority interests like data privacy driving things, and Jeff's talked about the interests of the Department of Justice and dealing with national issues in a consistent way. So let me start with Jeff. You just came from the Department of Justice Antitrust Division, heading up the New York office. And I'm sure you had many investigations where, while you were conducting a criminal investigation, state attorney generals in New York or elsewhere, because your jurisdiction was larger than just New York, we're also doing parallel criminal investigations. So what's going on behind the scenes with the Department of Justice and the state attorney generals to coordinate those prosecutions and make sure that they're done consistently in a timely kind of parallel fashion and not done with any undue burden or cost, both to the governments and also to the parties? What are you guys doing behind the scenes to make sure that goes in the right direction?
Yeah, I think it's a great question, and it's really it really stems from each component of the Department of Justice was tasked to create a parallel proceedings policy, and so to encourage cooperation and coordination among federal agencies. But I think that sentiment was taken across to foreign jurisdictions as well as to state and local jurisdictions, because as you pointed to the issues, Carl, there is a lot of money at stake. These are obviously bet the company type of investigations, and there's a lot of resources put in by the government. So for good government, they want to coordinate and try and limit where their resources are being directed in a way that's going to get basically the most bang for the buck. And the parallel proceedings policies that they have created really encourage that. And that goes to talking at the outset. The mantra was early and often, or at least that's again, this is the policy and a lot of the talking points that came out of the policy. Whether in practice, it's a lot more difficult in practice. But I'll talk big picture what the aspirations are. Talk early and often so you can dedicate those appropriate resources, and then see where the resources can be complemented by a state AG or the federal government, so that when they're getting then the documents, there may be a division of assignments, so there's not duplicative review. Maybe submitting those documents through one particular agency, and then that agency coordinates sharing amongst the agencies if they have sharing agreements among the agencies. And then, one of the things that, from my perspective, I saw that really could affect an investigation was what happens with the witnesses. Are the witnesses going to be brought, in 2, 3, 5, 10 times to different agencies? That is just bad. That's bad government. To try and limit that so that you have as many players in the room, or that they're sharing the interview notes thereafter, or at least a high-level review of what was said. That's the goal in order to limit resources not being allocated appropriately. So, you're going to have those discussions along the way. There's also going to be discussions about, if they are running parallel and maybe the information sharing is not as much as far as the evidence goes, they will talk about timing of key events. At least you hope so. So that there's no surprise either by what the federal government's doing or what the states are doing. But again, it's not a perfect world, and there's at times different views and interests on what's needed for the agency. But ultimately, they're trying to abide by, at least from my perspective, in the federal government, I'm sure the states would feel the same, by those parallel proceeding policies that are in place.
Jeff, thank you. That's very helpful. That answers the question. Let me kick it to Sean and kind of take it down another level, which is that's how DOJ and the Attorney Generals are trying to deal with each other in these parallel investigations. But among the Attorney Generals, as Steve talked about, there can be partisanship. Of course, they're all elected in different states. This is a federal system that we have here in the United States. How, as a defense attorney who's kind of deal with that on behalf of a client, do you navigate and try to control the various state attorney generals that are coming after your client, so it's done in a coordinated way where there's not, again, inconsistencies or duplicate efforts or delays? How do you navigate those waters?
Sure, and it's, there are similar dynamics whether you're talking about the dealings between multiple state attorneys general or multiple federal agencies or state agencies or all of the above. The bottom line is, and Steve touched on this some, but you can only do what you can do. That sounds simplistic, but you have to try to get as much coordination as you can as a practical matter, so that when you're going through the investigation, as Jeff has pointed out, when you're talking about resolution, as Steve has pointed out, at all of those points, you have to consider, can I and should I be looping in and trying to deal with people in a coordinated way when I give them the information and then when I ultimately resolve. You want, at the end of the day, a resolution for your client that is a real end to the entire process and not one that's going to be then redone in serial fashion with other AGs or with other agencies. And so that's the goal, but you can't always get there. Another tack that you can take on this, to the extent you can't get there, is when you're trying to fashion the relief with a particular AG or a particular agency or whatever entity you're dealing with, is to try to get relief that essentially addresses or forecloses the potential additional relief that might be sought by a different AG or a different agency. It involves thinking about what the different statutory regulatory regimes are that are available to the AG or whatever agency you and your client could be dealing with, to looking at the types of payments and the characterization of those payments, whether it's restitution or something else, or where the payments go in terms of, whether they go to a state fund or to victims, alleged victims of the conduct. All of those things can be worked into the resolution in a way that will at least give you the best chance of having finality and not continuing to then have serial resolutions.
That's very helpful. Let me throw it to Steve and make it even more complicated. You talked about, parallel investigations, state and federal. You, Steve, were, the U.S. Attorney in the Northern District of Ohio. You also ran for Attorney General in Ohio, so you've seen both sides of the fence. What do you do in a situation where it's just piled on? You have federal criminal prosecutions going on, you have state prosecutions going on, and the state prosecutions are being brought in various states, state courts, so you have federal and state courts all going on at the same time, and you're trying to deal with them at once. What's the best way of dealing with those situations?
So first of all, to state the obvious, and I think I've made my career on the ability to state obvious things. Look, it's unfair. It's horribly unfair. There's just a chance that you're really running roughshod over due process rights when you have these multiple different investigations going on at the same time. And you ought to be advocating. As Sean said, you can only do what you can do, but you got one thing you can do is be advocating on behalf of your client in that respect, that this is just simply not appropriate. I will say, Jeff talked about piling on, in the anti-piling on policy. I would say one thing in piling on is perspective, right? I think the Department of Justice, piles on itself sometimes, and I hope that will be checked, and but sort of piling on when other people do it. But I think we've all had experiences where the Department of Justice, whether there's a foreign prosecution or whether there's another action, sort of replicates the same thing, and forces the company to go through it again. So I guess what I would say is the key is managing client expectations. You should not overpromise your client. Sometimes you just can't coordinate everything because the independent regulators and enforcers won't do it. But you should be trying to use the tools that you have there, whether it's trying to corral the feds all together in some sort of a global negotiation or resolution, whether it's trying to make sure that there's a multi-state, whether it's trying to make sure that if there's other state regulators, whether they're insurance regulators or what have you, are somehow also using multi-state or coordinating with these other regulatory agencies. You need to try to use the tools available to you to do as best you can while telling your client to have realistic expectations that you cannot control everything, and you can't promise them that some regulator that doesn't want to play along or that you haven't thought of isn't going to come out of the woodwork later on in the process.
Good. Thank you, Steve. I think we've run out of time. This concludes our presentation today. You should know that all of these presentations, all three of them, will be available. They're all recorded. They're available. The slides are also available to you. And for those of you who participated in all three presentations, we thank you very much. We hope today's presentation has been helpful to you. And we thank the presenters for really giving a tremendous insight and based on their experience and their dealings with different regulators around the country and the federal government as well. So thank you very much, and all have a good day. Bye-bye.